Bailiff, you may go ahead. I assume, Marissa, we are live? Thank you. Bailiff?
Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. We are here this afternoon virtually again. This is our second session of the day, and due to the COVID-19 pandemic, we are being safe for our litigants as well as staff and participating this month on a temporary basis till further notice virtually. So with that in mind, I'd like to start. We have 3 cases today that will be submitted to the court. The first 2 will be by oral argument. The third will be submitted without oral argument. First case is State versus Hillery. Second case is Commerce Bank versus McGowan. And the final case is Great American Financial Services versus Natalia Rodionova Medical Center. The third case is hereby submitted without argument. Regarding the first 2, I'd like to do a quick sound check and then we'll go straight into oral argument. I'll start with you, Mr. Cmelik, Kevin Cmelik for the state. Can you hear me?
I can hear you. Can you hear me?
Yes, thank you. Now I'll move on to Martha Lucey. Can you hear me? Can't hear you. Martha, there you go. Okay, we just wanted to make sure we could hear you. Yes, yes, okay, thank you. And we will begin with State versus Hillery, and Ms. Lucey, you are up.
Thank you. May it please the court. My name is Martha Lucey. I'm the state appellate defender. I'm here representing Michael Hillery this afternoon. The district court order suppressing Mr. Hillery's statements and the controlled substances should be affirmed. Investigator Lenson induced Mr. Hillery to produce controlled substances and confess by a promise. The Court of Appeals found that there was no promise that would induce a false confession. What we have here is that the investigator told Mr. Hillery that he was not interested in taking him to jail that day. He was interested in his cooperation, and he wasn't saying that he would never be charged, but he wanted to get into the house. That prompted Mr. Hillery to produce crack cocaine. When he had it in his hand, the officer said, "You need to drop it." Mr. Hillery dropped the crack cocaine, pushed his bicycle into the investigator, and took off running. He was chased and quickly apprehended, and Mr. Hillery said, "But you said I wasn't going to go to jail today." And the officer said, "But that's based upon your cooperation. You better start cooperating now." This is not a case where there was a cooperation agreement at the time Mr. Hillery produced the controlled substances and confessed. A cooperation agreement may or may not have been entered into after the fact, but it was the promise of not taking him to jail which produced the drugs. So in this case, there was a promise. He was promised leniency, and the district court was correct.
Counsel, if I might, I follow this up to a point. The police officer says, "I know you bought something. You need to give it to me. I'm not going to take you to jail today." Then the defendant gives it to him. Where I get a bit confused is if that's the deal, how do I factor in then at that point he pushes his bike into him and takes off running? If they had a deal and he believed that they had a deal, why would he push his bike and try to flee?
And I can't speak to what was going on in Mr. Hillery's mind exact that moment. What the record shows is that Mr. Hillery maintained that he had done nothing wrong, that he didn't have anything, he had done nothing wrong. And the officer impeding his progress as he continued to say, "I haven't done anything wrong." And the officer says, I know you purchased something," but the officer didn't know he had purchased something. The officer suspected that he had purchased something because he was at this house where they had been investigating. So at the time that he pushed the bike into him, he'd already given up the crack cocaine. And then
But what
once,
was the promise? I mean, he made some statements, including, I don't want to arrest you today. A statement of present intent, maybe, but do we really have a promise here?
and we do have a promise here, because up until the time that the officer said, I'm not interested in taking you today, I want your cooperation, Mr. Hillery maintained that he had done nothing wrong. And it wasn't until he said, I just want your cooperation, you're not going to jail today. But he said, and then the officer followed up with, I'm not saying that you won't ever, you're not going to jail today if you start cooperating. I'm not looking to take you to jail. And it implied that if you cooperate, you're never going to jail. And he produced the crack cocaine, which was the cooperation. Sure.
Counsel, I think you lost me when you said it implied you're never going to jail, because before he dropped the crack cocaine, didn't the officer let him know that that's not to say you're not going to go to jail someday for this?
But it was in the context of cooperation.
By the way, can you cite a case for us where we suppressed on the basis of a promise of leniency when there was a cooperation agreement? I know you dispute the premise, but do we have a case in Iowa?
I cannot think of a case where we actually have, because most of the cooperation agreements, they become after the person has already been arrested and there already is evidence, and then they enter into an agreement at some point later, and whether the defendant lives up to the agreement is usually the issue. Here, we don't have an agreement yet. We don't have a cooperation agreement. We have the officer saying,
but what's wrong with that? I mean, why can't you have spur of the moment cooperation agreements?
because if you're going to have a cooperation agreement, there has to be some type of offer acceptance, and this is what you're going to get. Here, all he's saying is, I need your cooperation to get in the house. And Mr. Hillery is like, okay, I'm going to give this so I don't have to go to jail. But any cooperation agreement usually requires some other, how many buys are you going to do, whatever other conditions there are, and what the outcome is.
But Mr. Hillery never allowed it to get to that point, did he? I mean, how could you have had that conversation when he slams a bike into the guy and runs away? At what point should that conversation have occurred?
The conversation should have occurred before he was induced to turn over any controlled substances. The state focuses on the fact that this isn't what the state and the Court of Appeals focused on, the fact that this was not what, it wasn't going to likely result in a false confession. But here we have the officer believes that these drugs came from the house on Ellis Street. But we don't know that that's true until he's promised something. He gives up the drugs, and then he says, yeah, I bought the drugs on Ellis Street. So is that part of his statement? Would it likely induce someone to say something false in exchange for not going to jail?
Why would that rationale extend to the suppression of the physical evidence? As I understand the common law evidentiary rule, it really relates to the statement, and at least our cases have said there's reasons to question the reliability of a statement that's induced by leniency or threats. Seems to me that wouldn't extend to the physical evidence.
Because it's almost like when you look at the physical evidence became the confession of, here, this is what I have, that was induced by the promise.
Right, but the rationale of the rule isn't to deter police misconduct. It says the statements aren't admissible because of reliability concerns, at least under the common law evidentiary test. Those reliability concerns don't exist with respect to physical evidence.
Well, in the court's decision in JD F, the court was looking at the fact that this juvenile confessed to having the gun and took the officers to the gun, and that the court was open to the idea that the gun should be suppressed except for the public safety exception and inevitable discovery. So JDF shows that the idea of suppressing physical evidence based upon promissory leniency is not unheard of. You also have case where the defendant was induced to confess and sign a consent form for her apartment. The court was again open to the idea that any items from the apartment would be inadmissible, but for there is an independent search warrant that if you took out her confession. And again, McCoy is not exactly the same, but when you look at McCoy, the court said, we're not going to allow the state to impeach with his prior testimony even. So it's not physical evidence, but it goes beyond the statements.
Well, would you agree, at least, let's assume a Miranda issue, right? You don't suppress physical evidence that's obtained as a result of a Miranda violation. Right.
And I guess I would disagree with you, Your Honor, that in Dickerson versus Minnesota, I think that the Supreme Court did find that Miranda was constitutionally based and there would be a suppression of other evidence that flowed from that Miranda violation.
Should we find inevitable discovery here? I mean, he had probable cause to arrest. He smelled of marijuana. He'd been at a suspected drug house, quick in and out. I mean, was there probable cause to arrest? And that would have led to a search incident to arrest here?
It would not, for two reasons, Your Honor. One, there was certainly maybe reasonable suspicion based upon the smell of marijuana, but the smell alone of marijuana is not going to show that an individual is in current possession of marijuana.
But wasn't there enough for a Terry type pat down at least, reasonable suspicion?
There might have been a reasonable suspicion, but that's not what the state argues on appeal, even though that's what was argued below.
If they'd done a Terry type pat down, would they have discovered the drugs?
You know, it's on the record's unclear where the drugs were at. I don't think that we know where the drugs were on his person. We know very little about the marijuana. And going back to the search incident to arrest, even if you had probable cause to arrest, that doesn't mean that there was ever a present intention to arrest him, because Officer Lenson said, I don't want to take you to jail today. That's not my intent. And you can't have a search incident to arrest if you don't have a present intention to arrest. With a Terry pat down, I think that there may be reasonable suspicion. We don't know where the drugs were, but we also don't know from this record, and it's not shown from this record, that Mr. Hillery was dangerous at all. So can you do a Terry pat down in search of drugs based upon reasonable suspicion, or does it require probable cause and exigent circumstances, which we don't have here either? There may be probable cause that he has been in contact with marijuana at some point. He was at a suspected drug house. And again, suspected because it hadn't been proven. That's what they wanted to find out. And there's no exigency here.
Did their interaction on the street amount to a custodial interrogation for Miranda purposes?
It is our position that it does, because clearly he was not free to leave. That he, because the custodial doesn't have to be the level of an arrest. He was not free to leave. Which is borne out by the fact that when he did try to leave, he was quickly apprehended and brought back. I don't think the record shows that there was I don't think he was handcuffed, if I recall correctly.
But when you say he tried to leave, he shoved the bike first. Doesn't that kind of change the dynamics of somebody who just tries to walk away?
The officer had stood in front of his bike. He had impeded his progress. He couldn't go anywhere. When he was walking down the street, the officer was calling to him by name. The officer was in plain clothes. It's unclear whether Mr. Hillery knew who the officer was. So Investigator Lenson stood in front of him. He stopped him, stood right directly in front of his bike, impeding his movement. At that point,
Right, but I guess the point I was getting at was you said he tried to walk away. I thought the record was different, that he never tried to walk away. He pushed a bike into him.
he
and then
kept
ran.
walking. And then when his ability to move forward is impeded with the officer standing in front of the bike, they have the exchange. He gives up the crack cocaine after being told, I need you to drop it. And that's the point where he pushed the bike into him. But yeah, he clearly didn't want to be there anymore. If there are no further questions, I would ask that this court vacate the Court of Appeals decision and affirm the district court.
Thank you. State?
May it please the court. My name is Kevin Cmelik. I'm here today on behalf of Katie Crickbaum, who authored this brief. However, she's unavailable to present the argument, so I'm here in her stead. I'm the one in the office who gets to make the decision as to whether the state's going to ask for review of a district court order. And I can confidently say to this court, if all the district court had done was suppress the statements, it's not likely that we would be here. The fact of the matter is, in an interlocutory posture, we couldn't show materially the result would be different if we still had the physical evidence. We really don't need the statements to obtain a conviction in this case. But having said that, I am troubled by the district court's ruling in all respects. I think you have to look at what the district court did and understand that a one-size-fits-all analysis just cannot be used in this case to apply to each type of evidence that was obtained. We have three very distinct pieces of evidence obtained at different times. We have the crack cocaine, which was dropped/abandoned by the defendant before he effectively assaulted the police officer. We have the marijuana that was discovered toward the end of the encounter, and then we have the statements that he made. I submit to this court that in the posture in which the defendant challenged this encounter, you simply can't fall back on a promissory leniency theory to get suppression of all that evidence. I mean, look at the motion to suppress in this case. The defendant alleged only that there was an illegal stop and there was an illegal detention. There was never a challenge to the search in this case. There was never a challenge to the seizure of the evidence in this case. The only way the evidence gets suppressed is if the stop is shown to be illegal or the detention is shown to be illegal. There is no challenge to the actual search. The addendum brings up to the motion to suppress, brings up the 5th and 14th Amendments in kind of a half-hearted late addition to the motion to suppress. But at the motion to suppress hearing, the attorney actually said, I'm limiting myself for the purposes of this hearing to the 5th and 14th Amendment voluntariness claim. He wasn't even at that point alleging anymore the illegal stop or the illegal detention, and had never alleged that the search itself was illegal. In fact, when the marijuana was offered into evidence, the circumstances surrounding the seizure of the marijuana, defense counsel objected and said it was irrelevant to the issues before the court on this particular day. What clearer evidence is there that he had given up the argument about the search itself and was concentrating only on the admission of the statements? Having said that, I think the court was wrong in all respects. If you turn to the promissory leniency state common law rule, and you go back to 1874 when the doctrine was originally adopted in State versus Chambers, and you come forward to 2012 when that trilogy or 4 or 5 cases were decided of Polk, Madsen, Howard, McCoy, all of those cases, they all at their core have one particular fact in common, and I think Mullen points this out. The promise that's made, the promise that induces a false confession or likely a false confession has to be a promise that goes to mitigation of punishment or escape from culpability. It cannot go to any other issue, and it does not go to any other issue in any one of the cases this court will look at. In that context, there are other factors discussed, obviously. I mean, if you go back to the original cases like Chambers or Thomas in 1922, they're vigilante mob cases where the sheriff participated with a mob of 30 to 40 people to secure a defendant. And there are all kinds of threats and other type of misconduct being committed in the case. But still at the core, to get suppression, there has to be that promise that you will not be punished or your punishment will be mitigated by you providing us information.
Mr. Cmelik, this is Ed Mansfield.
Yes, sir.
I'm tracking your argument for the most part on the promissory leniency, but I am troubled by and you may say it's not in front of us, but I'm troubled by the issue of the crack cocaine, because even if we assume that the officer said nothing wrong, he then says, well, you need to give me what's in your hand. You need to give me what's in your hand. Doesn't that make this a non-consensual situation where he's demanding that the defendant turn over something that is in his possession? And therefore, there's an issue about the admissibility of the crack cocaine?
You're correct, Your Honor, that I will say that it's not before you. That search has never been challenged by the defendant below. And because of that, we don't have a development of the facts surrounding that particular incident that allows us to determine, was this a consensual search? Was this a search with exigent circumstances? Was this going to be a search incident to arrest? What we know is the officer did give the defendant a choice. You can give me the drugs and leave and be released, cooperate, or what's the other option? I'm going to arrest you and I'm going to seize those drugs anyway. So there is a sense of inevitability there, and there is a sense of exigent circumstances there as well. Let's not forget that the defendant didn't stop when asked. He was asked multiple times to stop and didn't ask.
So was it a custodial interrogation?
No, I don't believe it was a custodial interrogation, because let's not forget a Terry stop is detention. You're not allowed to walk away from a Terry stop. And that's precisely what this defendant tried to do. He tried to walk away from a Terry stop. The officer had produced his badge, showed it to him and said, I'm an officer, I'm here investigating. I want the drugs that you just bought at that particular house. And I would dispute the argument that there's only reasonable suspicion at this time. There clearly is probable cause to arrest. We have the drug task force surveilling the home of Charles Watkins. They know that Charles Watkins has a drug history. They have confidential informants that said Charles Watkins sells drugs. They had an informant that had overdosed on drugs he claimed to have bought at Charles Watkins' house. They had trash rips in which they'd found evidence of drug production and drug sales in Charles Watkins' house. They had short-term, high-volume traffic at that house. While surveilling the house, they see Michael Hillery arrive on his bicycle. He walks up to the house and engages in the same kind of short-term traffic that the officers had seen routinely at this particular location. They knew Michael Hillery. They knew Michael Hillery had a history of drug use and drug convictions. Michael Hillery left the house after this short encounter, and the officer, coincidentally, a separate officer also on the task force, sees him, follows him, asks him to stop, and when he doesn't, he follows Hillery and smells the marijuana. This court has made clear in State versus Watts that the possession of the odor of marijuana itself is probable cause to arrest somebody. United States Supreme Court said in Maryland versus Pringle, you could arrest everybody in the car for marijuana that was found in the glove compartment. The probable cause to arrest him was clearly there at that particular time. Now, to get back to the crack cocaine, would this case be easier if he had just arrested Hillery and said, I'm going to search you instant arrest? Well, absolutely. It would have been easier. But there's a reason why the officer didn't want to do that. You don't want to, one, trigger speedy indictment if you don't know exactly where you're going on the case. And then second, you don't want to out a potential confidential informant. So he made a decision at that point not to arrest, and in fact, told Hillery he would not arrest. I don't think in that context you can ever conclude that he was in custody for the purposes of Miranda. And quite frankly, because the defendant limited himself to the voluntariness question at the suppression hearing, we don't get development of those facts, unfortunately. And I would cite to another problem that arises as I think about that. Remember, in the promissory leniency state evidentiary common law ground, the burden is on the defendant to show that the statement was involuntary. It's not on the state. So the whole process here was confused by the way the issue was framed in the district court. How does the defendant carry his burden to prove that there was promissory leniency when he presented no evidence at the hearing? Beyond that, we know from Mullen that if it is clear as a matter of law that there was a promise of leniency, it's a question of law for the court before trial. If there's some argument about it not being a promise of leniency, an ambiguous statement, it's a question of fact for the jury. We don't suppress the evidence. We let the jury hear the evidence about whether there was a promise made and whether they can consider that in determining what the meaning of the defendant's statements were. I would submit to this court under Mullen that at best you have is an ambiguous statement, an ambiguous promise, but not a promise that is within the range of promises this court has condemned under the common law rule.
All right, and in terms of the error preservation, I was just checking the original ruling. The court just said promissory leniency, fruit of the poisonous tree. And
it was a little unclear what he was suppressing, but he said all evidence and statements.
But then the state goes in and asks for reconsideration and draws your distinction between physical evidence and statements, and the court rejects that. So isn't everything now in play?
Well, I think everything is in play. I think everything is in play under the original order. The thought in asking for the motion to reconsider or to amend was to clarify whether the court truly meant all physical evidence. It's not entirely clear, but it looked like that's what the court meant. The court then did, after the notice of or the discretionary review application was filed an order in which he said, yes, it's all evidence.
But at that point, isn't it the state's obligation to put in the evidence that either there would have been an inevitable discovery or there would have been an arrest, or some of these other scenarios that allow this seizure of the crack cocaine to be upheld?
No, I don't think so, because in the first place, the hearing was denied. There was just an order issued and no hearing allowed on that particular motion. And I think the issue itself on promissory leniency, that issue always remains with the defendant. It's always his burden of proof. I do want to talk about voluntariness for just a second. I cannot see a clock in my thing here. Okay, I got 2 minutes. I want to talk about
almost 3.
Okay, I want to talk about voluntariness under the constitutional principles before I close. The problem with that particular argument is I concede that evidence that's derived from an involuntary statement can be suppressed, but that evidence must be derived from the involuntary statement. It can't be just evidence that's seized in a case where a statement was given. There is no fruit of the poisonous tree. In fact, the evidence in this case was seized before any statements were made by the defendant. The state did not learn of the evidence because of the statement. The state didn't find the evidence because of the statement. The statement comes after the search. And so there can't be a derivative suppression in this particular case because the evidence doesn't derive from the violation that's alleged. So the voluntariness in this case is a red herring. It's not applicable to the facts in this particular case, nor is it applicable to the procedural posture of this case. I can't tell this court that all evidence that's seized as a result of a statement is separate and apart. It is in voluntary statement cases under Patani. In involuntary statement cases, I think this court made the point in Poker Madsen, McCoy even, we can suppress, we can't use the evidence to impeach somebody. We can't use the statement to impeach somebody because it follows an involuntary statement. But we don't have the connection here.
So I take it your view on the cocaine in particular is that there might have been a search and seizure challenge based on invalid consent, but that hasn't been raised in this case?
In an interlocutory appeal, I hesitate to advise the defendant what he should file when he goes back, but I will say that consent was not presented and there was no argument made as to a Fourth Amendment violation in this particular case. A stop and a detention violation, Fourth Amendment and Article 1, Section 8, was alleged, but not pursued. So
but this gets back to the question I was raising, Mr. Cmelik, I think, which is, all right, I understand your point. That wasn't how it was teed up originally, but the court then suppresses the physical evidence and the county attorney's office comes back and says, wait a minute, you're suppressing are you really suppressing the physical evidence? Because that's in effect a Fourth Amendment issue, right? And at that point, isn't it the state's obligation to say why what the district court did is wrong? Doesn't that order at least shift the burden on the state to do something? This was a warrantless situation.
I agree with that, but I disagree that it changed the burden somehow. The defendant did not raise the Fourth Amendment claim. It was not presented in the hearing in which the court decided the Fourth Amendment claim. It doesn't shift the burden for the state to point out to the court, hey, you reached an issue that was not raised. You reached an issue that was not presented by the defendant. I think it's what troubles me a little bit about this case is, when does the court step in and start raising issues for the defendant and deciding issues for the defendant and not somehow usurp a role as advocate? I think that's the problem with this particular case. If you had stuck to the issues that were raised, if the court had confined itself to the issues raised, I don't believe we would be here. And for those reasons, we would ask that you affirm the Court of Appeals.
Thank you, Mr. Cmelik. Ms. Lucey, you may respond.
Hey, Chief, I'm sorry, I was slow to get my mute off. Could I ask Mr. Cmelik one last question?
Absolutely. Sorry, obviously I didn't hear you.
Well, I was slow to get my mute button off. Counsel, is it proper to use a promise of leniency? Assume they cross the thin line. Can you use that to suppress physical evidence?
I think that you would have to expand the doctrine beyond what it's been defined in previous precedent. And that's what concerns me about the district court's order. Not only did it reach an issue that I think was not fairly presented, it expanded it beyond the scope of any parameters that this court had previously defined. Could you expand the doctrine and say derivative evidence obtained as a result of the statement is suppressible under the rule? I think you could. But I think it should be derivative evidence, and this is not.
Okay, if there's no other questions, either raise your hand or turn off your mute buttons. Okay, thank you. Ms. Lucey, you may reply.
Thank you, Your Honor. I think there's one thing that the state and I agree on is that the record is maybe not the best for a lot of these questions. But why is the record not the best for these questions? Potentially because of what the state did. After the district court filed the order suppressing the statements and the drugs, the county attorney's office filed a motion for reconsideration. The state then filed an application for discretionary review. It is my memory, but I don't have it in the appendix and I don't have it in front of me. So I'd ask the court to look. I don't believe that the district court denied the motion for reconsideration on the facts, may have specified what was being suppressed, but I believe this court had granted discretionary review before the district court ruled on that motion. And if I'm wrong, then I'm wrong. But believe there's-
I think you're right, but then the court, the day after that was filed and before our court acted on it, entered a short ruling denying the motion to reconsider.
Okay, and I'm not sure. The second thing is that the state, in its application for discretionary review, did not allege as error that the court ruled on an issue not raised. If you look at page 23 of the appendix, the state said the error is twofold, saying that you don't suppress the physical evidence and that there was a cooperation agreement. Nowhere did the state say the error is that the district court ruled on the evidentiary common law test instead of the voluntariness. That wasn't preserved for the court. Just like I can't turn around and say counsel was ineffective for not not asserting all these other grounds. What we have below is the county attorney says that it is a reasonable suspicion on appeal. The state is now saying probable cause and exigent circumstances. We have a record that is what it is because of what the state did below and on appeal. So
I have a question for you, Ms. Lucey. The state argues in its brief to abandon the evidentiary test, Madsen and some others. Can you comment on that?
I believe this court, as recent as 2012, declined in Madsen just for the reasons that Madsen found that the bright line rule is the easiest to be able to apply. You don't have to get in the mind of the defendant. The court went through and acknowledged that there were some benefits with going with the involuntary test instead of the constitutional, instead of the evidentiary, but the court declined. Nothing has changed for this court to change its mind at this point. The state.
I agree with you on that. But I may disagree on whether this crossed the line into a promise of leniency. Wasn't the officer, it was within his discretion to decide not to arrest today, and he was true to his word.
He was true to his word that day, but that's what prompted Mr. Hillery to produce the cocaine.
But he's also warned before he dropped it that he might be charged later.
And I think that that's a little unclear exactly when he said, I want your cooperation. I do believe you're correct that he said, I'm not saying that you're not going to go to jail someday for this, but that would have been based upon his cooperation. He cooperated by giving him the drugs. Okay, granted, he ran away, but then again, he produced the marijuana in that idea that he was cooperating, that he wouldn't be charged today. And I'm sure the implied promise that you won't be charged ever if you help us get into the house, because that's what we want. I don't believe that what we have here is a search at all. We have a seizure, we have a promise, but I don't think that there's a search. Could there have been a search in the hypothetical world? I submit no.
Miss Lucey, given your comments earlier about the record, what would be wrong with a disposition that the district court's order be vacated and just the matter be remanded because the district court's deciding issues not presented, and we're all speculating about what may or may not have happened or what record may or may not be made on issues that are not before us? It seems like you were amenable to that.
I don't believe that that's necessary at this point. That would be my alternative remedy, Your Honor. But the district or the Court of Appeals found that Hillery's citation to Howard and Polk did raise the evidentiary. My position is that the footnote in Madsen that the district court should employ that test first is the instruction to do so. It's not qualified. It says the court should apply the evidentiary test prior to going to a constitutional. That's what the district court did. And that's not what the state complained about in its discretionary review. Now,
Let me, if we decide, I know you don't agree, but if we decide there was no improper promise of leniency under Madsen and Polk in those cases, and if we decide there was probable cause to arrest Mr. Hillery, what do you have left?
If there was probable cause, we still don't have any present intention to actually arrest. So without, you can have probable cause, you have to arrest in order to do the search incident to arrest.
So in other words, he needed to say something like, I'm going to arrest you unless you cooperate. Wasn't that kind of implied?
Actually, I don't think it was implied, because at that point, if he had said, I know you purchased something, I am going to arrest you unless you want to help me. But Hillery just kept saying, I did nothing wrong. I did nothing wrong. And we have to go back and remember that the facts of this case is Lenson did not see what happened at the door. He went by, he saw Hillery ride up. 3 minutes later, he went back, he saw Hillery ride away. We don't have an exchange. What we have is the officer was suspicious that this happened. And that's all we have is his suspicion based upon that Hillery is a drug user, or they believed he still was a drug user, and that they thought that the occupant of the Ellis Street house was dealing drugs. Were there some type of indication that he may have been dealing drugs? Yeah, but they were still in the process of this investigation. Even by the time of the suppression hearing, it was an ongoing investigation. So
You may wrap up, Miss Lucey.
I'm sorry, I still see 3 minutes.
Oh, it's going up. It's going up.
I'm so sorry.
That's
I'm
okay.
so sorry.
Well, then you could probably keep talking all day long.
Actually, Your Honor, you know me, I probably could. I would ask that this court affirm the district court. Thank you.
Thank you. No, that's tricky sometimes. You're not the first. Okay, thank you. The matter of State versus Hillery is hereby submitted. And we will take a brief break to transition to our next case.